We're going to begin the next set of talks. We've basically given you a set of talks that frame the issue. That was Allison and myself. We gave you some case studies of ways to make new animals, both past and present, to think about. And now we're going to take a look at the adequacy of oversight of different forms of genetic editing and germline engineering. Our first speaker, Andrew Torrance, is from the University of Kansas School of Law, and he's going to tell us what we've learned from GMOs.
Thank you very much for that kind invitation, and thank you also very much to the organizers for having me at this conference. I've learned a tremendous amount. I'm not guaranteeing you'll learn anything from me, but at least I'll be done in 25 minutes. So I wanted to start with a Jean-Luc Godard quote, because why not? Every edit is a lie. I don't know how true that is with respect to gene editing, but we'll see as time passes. So I like to give a quick overview of what I'm talking about so that I remember. Talk about a couple of introductory things, including definitions. Then I'm going to tell a sort of a Chaucerian tale, a variety of different vignettes from the history of regulation of GMOs. Then I'm going to talk about something that's come up a number of times in this conference already, which is democratization of biology, something that I'm very interested in, something that I've done a fair amount of work on, and I'm just very excited about the implications for policy, law, and science. And then I'm going to talk very briefly about some lessons for gene editing and gene drives. And then I'm going to essentially let the other two speakers drive the rest of it. I'm not going to offer magical solutions. I'm mostly going to set the table and try and explain where we've come from. So what does genetic modification mean? Is it selectively bred, hybrids, slightly engineered, massively engineered, gene edited? I'm not sure we're clear on that yet. I'm certainly not clear on that, but I think that we ought to bear in mind the fact that the terminology is very important, and the terminology is being used to squeeze all sorts of ideas into it. At some stage, really good definitions, a consensus on definitions could be valuable to this whole issue. The salience of products versus process, I want to throw a spanner into the works there too. I know that the federal framework is largely premised on the idea that products and processes are distinct. Gene editing, sure, it's a process, but I want to suggest that if there is a process that has such huge advantages of efficiency, speed, accuracy, is it possible that that process actually makes the product meaningfully different? And again, I'm not going to offer an explanation, perhaps Hank will, or a way to sort of answer that question. But I do think that sometimes you come upon processes that are so different that what they make may by implication also be different. So genetic engineering has been used a lot so far, and editing as well. So I just wanted to get an Oxford dictionary definition of both. Engineering, the branch of science and technology concerned with the design, building, and use of engines, machines, and structures. Editing, by contrast, preparing material for publication by correcting, condensing, or otherwise modifying it. To me, these are very different ideas. Of course, they overlap, but the fact that we call this new process gene editing may be significant, it may be superficial, but again, I want to sort of draw some contrasts and offer the possibility that we're at an inflection point or a change point from the way we've done things and the way that we're going to do things. Does genetic engineering imply a meaning different from gene editing? Well, does it imply a pre-existing text, for example, rather than a blueprint? The precision of the changes, is that a significant difference? And improvement rather than transformation, those are different ideas again to me. I offer no answers. Is this significant for regulation? I suspect that it is, and I suspect that it increasingly will be. So I want to start with ASILOMAR, and I won't say too much about it because I think Professor Greeley is going to address it, and its sequel, the NAPA meeting. Organized by a luminary in the field of molecular biology. About 150 folks showed up, not just scientists, but also attorneys. They get in everywhere. You can't keep them out. And it was sparked, I think, by a number of things, but sparked at least in part by fears over the recombinant DNA biohazards, including in Paul Berg's own laboratory, the splicing in of a viral sequence of DNA. Even some of his own colleagues asked him not to do it. And so this conference was organized. I see it, at least in part, also as a preemptive strike against excessive imposed regulation from outside. There were some fairly, I think, impressive agreements that the participants came to, including, multiple levels of containment based on risk of the technology, the process, and the products involved. And also, I think equally important in the long term, deliberate engagement with the public on scientific issues in order to allay fears, to explain things. I don't think this is something that we as a scientific and regulatory community have really, I don't think we've kept the spirit of it up as much as we should have. I think engaging the public is vital because when you start to regulate, when the rubber hits the road, if the public disagrees with the regulation despite its logic, despite its scientific basis, I think the regulation can easily fail. Largely, I think, successful in staving off federal regulation, or at least excessive regulation as viewed by the scientists. And then there's the 2015 sequel. I see it as a sequel. The meeting in Napa, both lovely places. ASILOMAR, I think, has not as good local wine as Napa does. And again, I'm going to leave sort of discussion of it up to Professor Greeley because he was there and he was immersed in these subjects, and he was part of the declaration that came out of it involving the moratorium on germline modifications. And I think he'll probably want to talk more about that. Germline modifications, very, very significant issue. I am not able to address it too much in my sort of summary of the history because it's not always been the central issue, but it's lurking there now, certainly with respect to human beings. So let me skip quickly to patents, and then I will skip quickly away from them, so don't worry. In 1980, what I see as a very significant regulatory event happened when the Supreme Court decided that a genetically modified bacterium, the oil spill bacterium that Ananda Chakrabarty came up with, would actually constitute patentable subject matter. So to an extent, it would become ownable property, and it would confer on its owners the ability to exclude others, at least in the private world of litigation, from making, using, selling, etc., this living organism. Now, this decision opened the floodgates for all sorts of DNA patents, including lots of laboratory research animals. The Harvard oncomouse is sort of the poster child for this. And it turns out it was patent eligible, continues to probably be patent eligible in the US, although there's a little bit of uncertainty now in light of a few Supreme Court cases the past few years. But I do want to draw a quick little contrast, not just because I'm from Canada, but in part, I think it's interesting that although the US accepted the oncomouse as patentable, Canada did not. The Supreme Court in Canada actually said that so-called higher organisms could not be subjects of patents even when genetically modified. Now, despite the fact that Darwin once wrote in the margin of one of his books, never say higher or lower, and it's, I think, a maxim that I hold to because I see no difference between higher and lower. The Canadian Supreme Court said mice are higher organisms, good for mice, but they're not ownable as patents. One of the things about gene editing that just lurks in the back of my brain, there's been a couple of folks, including myself, who've talked a bit about the possibility of applying copyright to DNA, especially human modified and specifically edited DNA. Gene editing, at least metaphorically, appeals very strongly to the idea that if patents are not the right way to regulate, what about DNA copyright? What about the possibility that as we start to compose things in specific ways, that the copyright statute starts to attach to DNA? So let's talk about the coordinated framework. Don't laugh when I say coordinated. Some people think that it's very well coordinated. 1986 renewed in 1992, and I think there's some movement in this building to re-renew it or maybe to re-coordinate it. Although that hasn't been done yet. A number of principles: products, not processes, regulation based on verifiable science, and GM products adequately regulable under the regulatory frameworks that existed then and exist now. The approach can be piecemeal. So an example from GM crops, not animals, but crops, the FDA provides voluntary pre-market consultations on safety. APHIS licenses field tests of GMs. The EPA registers pesticides, including those engineered into plants. So it's not a one-stop shopping proposition when you try and get a genetically modified organism licensed and permitted by the federal government. As I noted early, a couple minutes ago, I think there's a movement, and I think this is a very positive movement, to look into the coordinated framework again and see if it can be improved in efficiency and effectiveness. But that may take money and time, and don't hold your breath. States have not given up everything to the feds, and there's a number of sort of themes that emerge at the state level. Bans, for example, Boulder, Colorado. Food labeling, the New York Assembly has insisted on certain food labeling regulations. Some of these conflict with federal law. Sometimes they're struck down on preemption grounds, but there's a lot of efforts at the state level to regulate. Zoning also, so Monterey in California, Monterey has zoned itself to avoid genetic engineering experiments. I'm not sure how they enforce that. I'm not sure that it's effective at all, but politically very popular, I'm told. Under the common law, there's a variety of theories that would seem to apply to the sorts of organisms that may emerge out of gene editing and gene drive technologies. I'm going to table that for a second because one of my last slides talks about strict liability, an ancient idea that maybe needs to be resurrected. There's always tensions, though, between the feds and non-fed power in regulating GMOs, and this is not always helpful in coming up with rational regulation. Now, the EU also regulates genetically modified organisms, and a lot of their focus is on releases. So, for example, Directive 2001/18/EC talks about living organisms that may be released and what the risks of those are, and release should occur in carefully stepped, staged operations. The member states, however, do not religiously follow this directive, even though it's law in each of their jurisdictions. So I want to talk briefly about the GLOFISH. We had a really nice presentation this morning, so I won't belabor very much of the sort of the basics. A number of federal agencies sort of stepped back from regulating the GLOFISH. They may have wanted to, but in the end, the FDA was sort of given the baton. A couple of ways the FDA could have decided to regulate potentially was as a new animal drug or as food. And although I had a quick chat yesterday about the possibility that the sushi, the GLOFISH sushi episode may have been a hoax, I imagine GLOFISH have disappeared down the gullets of many sorority and fraternity house brother or sister. So who knows? Does that count as food for the FDA? I'm not sure. They're available for sale throughout the US except in California, but I'm told that is about to end. So California also is going to start selling glowies. Why no formal regulation? Now, we heard this morning that there was regulation under Guidance 187. I want to just clarify, someone that teaches food and drug law, a guidance is not law. It's not legally binding at all. Even the FDA explicitly says that it's not. So voluntary compliance, that's highly laudable, but it's not being legally regulated to the extent that, that other things are which require permitting and licensure from the FDA. So I think the GLOFISH incident, hopefully you'll get the Sherlock Holmes citation here. The GLOFISH incident, it sort of indicates some holes or some looseness or some uncoordination in the framework. Cartagena Protocol, possibly the only so far successful part of the Convention on Biological Diversity, was adopted in 2000, not in the US, entered in force in 2003, fairly popular in other countries, not in the US, adopted a precautionary approach and aimed at regulating the transboundary movements of living modified organisms. One of the ideas in the Cartagena Protocol is to give notice to other countries, specifically so advanced informed agreement and notification to take into account things like risk, and to guard against unintentional transboundary movements and emergencies of what they call living modified organisms. If I go back to the objective here, the objective is not to squelch the movement of these organisms entirely, but it's certainly to control it. And given these provisions here, I think it makes it quite difficult, if you comply with CARTAGENA, to get living modified organisms across borders without a fair amount of official formal regulation. There are other international treaties which are germane. I won't go in detail, but the International Plant Protection Convention also covers aspects of animals that have implications for plants, including genetically modified organisms that could become pests. Now, again, my thunder's been stolen with respect to the diamondback moth. One of the things that I think is interesting about this case is how little attention it received, despite the fact that there were cage trials and open field trials, or there will be open field trials. I think that here it's very species, it's very species specific, possibly, is the explanation. Moths are not viewed as terribly dangerous, and these diamondback moths are considered terrible pests. They're invasive species. They're the largest predators of brassica plants in the world. All sorts of other countries have struggled mightily against trying to eradicate them. So I think that they're a special case. The mosquitoes have run into a brick wall. I'm not sure exactly what explains the difference, but I think there's something to do with human disease that bothers people, possibly more so than eating of plants. But I'll leave that for others to sort of speculate about. But I do think it's interesting the difference in the treatment of two insects, both of which fly, both of which are pests, one of which has had open testing and the other has run into what seems to me to be a fairly strong wall so far. But others are more qualified probably to comment on that. So again, the AQUADISADVANTAGE presentation, I think, discussed most of what I wanted to talk about here. All sorts of ways in which it could have been, all sorts of ways in which it was reviewed. A new animal drug, food, there were ethical inquiries. NAPA was invoked. A lot of confusion and delay in how to actually do the review. The review finally did get done. We now have a resolution. And as was pointed out yesterday, the process in Canada was much, much quicker. I'm not saying that the Canadian process was better, but it would be interesting to look in detail into why the Canadian process was so much faster, and I think more efficient than the US process. And again, this goes back to the coordinated framework, and maybe we ought to take a look at it. So strict liability is something that in the law is relatively rare. Generally speaking, it's a legal doctrine that's invoked when there's an inherently dangerous, usually animal or substance or activity that threatens others nearby. And the original case involved a reservoir which leaked into somebody's mine. And the idea in strict liability is that we don't really look into why somebody engaged in the activity. We just look into whether they engaged in the activity and the activity had damage. Now, I think strict liability is quite likely to become applied to things like gene editing and gene drives as a legal doctrine. Because I think the public, at least, and some beyond just the public, view these technologies as raising concerns, in part because of their ease, that are akin to keeping a lion in the backyard. Strict liability doesn't say you can't keep a lion in the backyard, but you have to take all sorts of precautions to make sure it doesn't bite the neighbor's arm. Now, democratization came up a number of times, so I want to take a really quick spin through democratization and how I see it as applying to CRISPR-Cas9 and gene drives. Notice that this is the cover of Nature, and it's a comic book. It's a comic book because the whole idea behind synthetic biology and the folks that are pushing it as a field is to bring it down to the level of individual citizens, to high school students, not to keep it enshrined behind the doors of laboratories. Synthetic biology has a number of goals, but one of the goals that is key, at least to the prominent founders, is open source ethos, the idea that things should stay open and it should become a participatory activity, not an exclusive proprietary activity. Number of important milestones that show, I think, proof of concept of some of the methods, including, and I just finished this book. I didn't read it in the DNA form, I read it in the book form, but the book was actually coded into DNA as proof of concept of DNA storage. Institutions in synthetic biology have deliberately proliferated. The folks that set up the field have tried to create all sorts of ways that citizens, scientists, et cetera, can interact with one another and sort of co-govern the principles of the field. The BioBRICS Foundation, one of the most prominent of these institutions, and they managed until recently the Registry of Standard Biological Parts, and they run an Olympics, the International Genetically Engineered Machines Olympics, which is so gigantic it now, it's outgrown MIT, it's now at the downtown Boston Conference Center. And the idea here is that open works better than proprietary, especially for the basic building blocks of biology. So the registry, which used to be a freezer in the hallway at MIT, with no lock on it, now has more than 8,000 genetic parts. It's growing very, very rapidly in size, and it's there to provide a reservoir of already made standard parts that folks that want to engage in synthetic biology can use as starting points instead of reinventing the wheel each time. There's standardized formats, there's specifications for the parts, so you can understand how to use them and make them. Here's an example of a part. And there's all sorts of standards, and for full disclosure, I wrote a report for the National Academies on technical standards and standard setting in synthetic biology. So biosecurity standards were also something that have come out of synthetic biology, and this is something that I think the CRISPR-Cas9 gene drive issue should consider. Now, initially there were a number of different proposals of how to regulate biosafety in synthetic biology, given the fact it's so democratized. In the end, it was HHS that swept in and imposed a standard, and perhaps it was a good thing because there were warring standards and they couldn't decide how to govern potentially dangerous sequences. One of the things that synthetic biology has done, which is interesting, is to come up with an open source biology license, which is sort of a constitution. I had a small hand in helping to draft it, but the idea was that it would encourage people to behave responsibly in giving parts and in using the parts, and to try and use synthetic biology for good purposes, not for ill. I've already mentioned the IGEM competition. It's gigantic. It now involves do-it-yourself bio teams and high school teams. And one of the interesting things they do is they contribute parts back. So they use the standard parts and they make new parts for their Olympic contests, and they contribute it back. And I've gathered some data, and all you really need to see here is the trend. Lots of participation increasing, and the white bar is contribution back of parts. The black bar is use of existing parts. People love to contribute back. That's why the registry is growing so quickly. They use parts, but they love to contribute back, which is confounding to some economists. They do it in a variety of different areas, therapeutic, diagnostic, et cetera, and a variety of different types of biological parts. This is from a forthcoming paper. So I want to finish up with user open and collaborative innovation, the idea that non-company, non-laboratory scientists may be doing all kinds of interesting things with CRISPR-Cas9 and gene drives. The idea is that users often innovate to satisfy their own needs. They come up with really important inventions, including the heart-lung machine, for example. It's not trivial, and economic surveys have showed that it actually dwarfs in some countries the amount of R&D spent by companies. And they come up with important technologies, including these. This is an accounting of the users versus the manufacturer's contribution to important technologies. The Commerce Clause is one of the batons that the federal government can use to regulate biotechnology. But what's interesting, there's been, I think, a slight movement of skepticism about whether the Commerce Clause can be used to get down to the level of democratized innovation, to citizen innovators. Agency statutes also specify that they cannot go beyond commerce as the level at which they regulate, including FDA, EPA, USDA, organic statutes. There's even a case in California, a terrible case where a creepy old DJ gave GHB to teenagers from a converted ice cream truck, killed a kid, and the FDA came after him on criminal charges, and the Ninth Circuit said, FDA, you don't have any jurisdiction because he gave it away for free. You must regulate commercial activity. Privacy is also something that sort of girds up this citizen innovation. Free speech allows the citizens to communicate these ideas, even crazy ideas, even ideas about trepanning, drilling holes in your head to relieve your migraines. And I'll finish with a quick case study, which is continuous glucose monitoring. It's not exactly the same as Cas9 and gene drives, but the lesson, I think, is a strong one. There's a big problem in type 1 diabetes is monitoring glucose. And it's a hard enough problem for adults, but it's a terrible problem for kids. Kids are terrible at monitoring. So a group of innovators came up with a way to hack a device to make it available on an iPhone. This caused all sorts of fuss, but it allowed unprecedented freedom for the people who have continuous glucose, who need continuous glucose monitoring and their children. It caused a gigantic regulatory problem. The FDA tried to pressure the device manufacturer. They tried to pressure the hacker community. Basically failed in both cases, and in the end, encouraged the company probably to apply for a license to extend the capability of the device, and approved the change the device in a month, which is an incredibly fast turnaround time. So it's sort of an example of regulatory hacking, an example of the power of these groups of citizen innovators who are in some ways beyond regulation. There's other groups like Patient Like Me who carry out their own clinical trials on themselves, much to the consternation of the FDA. Night Scouts, including folks trying to come up with an artificial pancreas. And I think gene editing and gene drives, if anything, will facilitate citizen innovation in all sorts of forms we can't imagine right now. I've already talked about strict liability. What I want to finish with is just to say, I think legal regulation has been, mixed in its effectiveness. It's not necessarily, I think, a great template for how to regulate a technology as powerful as this. It takes a long time to regulate in the quote-unquote proper way. I'm not sure we have time anymore, given the proliferation of possibilities that these technologies allow. CRISPR may accelerate the creation of new GMOs so much that the agencies become overwhelmed. So what happens? Do we exercise bans over it? Do we streamline regulation somehow? Do we outsource regulation to industry? Or is it at the effective end of regulation? Will gene editing and gene drives lead to editing of the coordinated framework? I would predict that it will. I would predict that these and maybe their successor technologies will force the hand of regulators to come up with a new, more effective, more efficient, and more public accepting form of regulation. So thanks very much.